Good afternoon. The subject of this video is consent. Consent is basically the person waiving his right to the Fourth Amendment privilege against unreasonable searches and seizures. An individual may choose not to assert his Fourth Amendment right against unreasonable search and seizure. When the individual consents, a search without a warrant or probable cause is valid. A person's consent to search must be voluntary in order for it to be valid. When is consent voluntary? The question is whether the consent to the search is voluntary under the totality of the circumstances. We must objectively consider the totality of the circumstances. Several factors are considered, and these are factors that the court will consider in order to determine whether there was the consent that given to the search is voluntary. The voluntariness of the defendant's custodial status. If the defendant is in custody, was he voluntarily in custody? Or was there some explicit manner of coercive method used by the officers in order to effectuate their custodial status? The presence of coercive police procedures. The extent and level of the defendant's cooperation with the police. The defendant awareness of his rights to refuse consent. That one is really interesting because the state does not have to tell the person that he has a right to refuse to consent, much different from Miranda, where Miranda is required by the Fifth Amendment. It's required that the person is told that you have a right to remain silent, not with the Fourth Amendment. It is not required that the police officers tell a person that he does not have to consent to their request to search. And it will be a valid search if all other circumstances are met. It's interesting because how many people are going to say that you cannot search when a police officer, under presence of the appearance of his authority, acts to search? Therefore, it appears to me that it should be the same as the Fifth Amendment, that there should be a requirement that police officers let a person know that you do not have to consent to a search. The defendant's education and intelligence is another factor. And the defendant's belief that no evidence will be found. That one's crazy. It has never been used. Don't even consider that. None of the factors alone is dispositive. They all must be considered together. While knowledge of the right to refuse consent is important, it is not by itself determinative. It is not necessary that officers advise the suspect of the right to refuse if other circumstances indicate that the consent was valid. Courts are to look to the tactics used by the police to secure the consent as well as particular vulnerabilities of the subject. They look at his, for example, they look at his age, his intelligence, level of education, emotional state to determine whether consent was coerced or voluntary. Further, the court has held that a person need not be given warning that he can refuse consent to search even while he's in police custody. The state bears the burden of proving consent was freely and voluntarily given. To be freely and voluntarily given, the consent to search must not be a product of official threats, pressure, intimidation, or harassment. Mere submission to authority does not constitute consent. Let's take a look at a couple of examples, and I want you to tell me what your thoughts are. The police have an arrest warrant for a person and were told by an informant that the person was in a particular apartment. Two policemen came to the apartment at 2 a.m. equipped with guns, handcuffs, and nightsticks and walkie-talkies. When the 17-year-old defendant answered the door and told police that he did not know the person they were seeking, the police insisted in checking the identity of the defendant's companion, who was seated on the sofa. The defendant allowed them to enter the apartment. While checking the companion's identity, the officer saw marijuana residue and both occupants were arrested. Was the consent valid? Let us see what we have. They come to an apartment at 2 a.m. in the morning. There are two policemen equipped with handcuffs, guns, nightsticks, and walkie-talkies. They approach a 17-year-old and they ask him about someone. He says, "I don't know about the person." Then they became interested in the person who was in the room. And they asked, could they come in? He says yes. And they said that their consent was valid. What do you think? Tell me what you think. What do we consider? We consider a person's age. He's 17 years old. We consider the circumstances. 2 o'clock in the morning, you have 2 police officers fully equipped. You consider the fact that the person, that the 17-year-old is probably not of any not of low intelligence. There's no indication that he has a low level of education. There's no indication that he has some emotional state that may prevent him from consenting. So, how would you decide? Was this consent a valid consent? The 17-year-old at 2 o'clock in the morning, officers come to his door and ask him if they can come in, and he says yes. His attorney argues that the consent was not valid. How would you, what would you argue? Was it freely and voluntarily given? Can the state prove on the totality of the circumstances that the person actually consented with all knowledge of his rights? That's not required. The next hypothetical. Police officer requests to search a suspect's car, which is located in her yard, when she is arrested. The suspect responded no. The officers then told the suspect they would obtain a search warrant if she did not consent. Is a subject consent valid? Is a subsequent consent valid? They arrest her in her yard. She's arrested. You ask her, can they search? She says no. The officers tell her that we're going to obtain a warrant anyway, and so you may as well give us consent. Is her consent valid? Was there an implicit threat or an explicit threat by the officers in order to gain their consent? That their statement put pressure on her to give consent. Would you consider that consent to be valid? The defendant was a passenger on a bus when he was confronted by the armed officers dressed in green jackets who were sweeping the bus for drugs. When they displayed their badges and asked if they could search his luggage, he agreed. He was advised by the officers that he could refuse their request. The defendant consented to the search. Was the consent valid? Armed officers with badges on the bus asking if they could search his luggage. He consents. They also told him that you can refuse. Was his consent valid? Third-party consent. Now, this becomes really interesting when we talk about consent. Whether a third party can consent to the search, and when there's another person that lives in the apartment or live in a home. Third-party consent to search rests on the mutual use of the property by persons generally having joint access and control for most purposes, so that it is reasonable to recognize that any of the co-inhabitants has the right to permit the inspection of his own right, and that the others have assumed the risk that one of their number might permit the common area to be searched. Let me break that down for you. If you have an abode, if you have an apartment, if you have a place that is inhabited by more than one person, the co-inhabitants assume the risk that one of the other inhabitants will allow a search of the common areas. What are the common areas? The kitchen, the living room, the dining room. Those are common areas. But I cannot permit you to search my private room. My private room I cannot give consent for the purpose of searching my private room. There's an expectation of privacy in my private room if the house had separate bedrooms. Now, if we have the same bedroom and we're staying in the same bedroom, that becomes a common area. And I can allow officers to search under certain conditions. We'll talk about that in a second. However, officers, when you have co-inhabitants, again, common areas, anyone can give consent. Private rooms, only that person who has the right to the private room can give consent. A third party need not have actual authority to give consent, only apparent authority. The test is whether facts and surrounding circumstances known to the officers warrant a man of reasonable caution to conclude that the consenting party had authority over the premises. Consent is valid if actual authority is absent. Ownership or legal authority to enter the premises is not sufficient. When there is apparent authority of a third party to give consent, the officer's reasonable belief will validate the entry. This one is really interesting. There's no need for the officers to determine that the person has actual authority. The person, a third party, a party who allows consent, does not need to have actual authority. He only needs to have apparent authority. Now, what is apparent authority? It is apparent to the police officer based on the circumstances, based upon the circumstances surrounding consent, that the person has the authority to give consent to search the premises. Let me give you an example. Person comes to the home, an adult answers the door. Knock on the door. Good afternoon, how are you, sir? Police officers, we're looking for X, Y, and Z. Can we have the authority to search? Do we have the authority to search this home? If that person consents, many times, for the most part, the court is going to say yes, because the person has apparent authority. The child answers the door, no apparent authority. If the police officers know that the person doesn't need to live there, there's no apparent authority. But if it's apparent, if it's objectively apparent to a police officer, and a police officer reasonably believe that the person has the right to give the consent, that entry is going to be validated. That entry is going to be constitutional. And so they do not, again, need actual authority. Police officers only need apparent authority for the purposes of entry. Go to the door. Maid answers the door. Police officers only need apparent authority. Now, if police officers go to a home and the door is open, do they need consent to come in? Good question. We'll talk about that in a minute. One of the things that many people run into, can an apartment manager permit a search of an unleased apartment? Yes, he can. He can permit the search of an unleased apartment. Can he permit the search of a leased apartment? No, he cannot. He cannot. Now, what is the scope of the consent? The allowable scope of the consent search is determined by the permission granted. This is gauged by a standard of objective reasonableness. What degree of search is reasonable considering the permission given by the individual? In Florida versus Jimeno, the court found that when police were given permission to search a car for drugs, that consent included the search of containers. They concluded that it was reasonable that the person might expect the officer to look into containers for drugs. The consent was given to search for drugs. Now, the scope of the consent is going to be determined by the permission granted. The scope of the search for which a person has given consent is going to be determined by the permission granted. If you grant them permission to search for a particular thing, they can look in those areas where that particular thing can be found. If you give them consent to search only a particular area, they can only search that particular area. They come to your house, can we search? Yes, you can only search my closet. They cannot search anything else. It's going to be based on the permission that is granted. And so it's important the permission to determine what permission a person has given to the officers to search. Example, defendant telephoned her daughter for help, saying she had shot her husband and taken an overdose of pill. Daughter did not live at the home, but she had a key. The daughter called police when the mother went to the mother's home and let the police into the house. Her mother was then unconscious in the house. Police conducted a lengthy search, seizing several items. Was that search valid? Was it a valid search? Defendant telephoned the daughter saying that she just shot her husband. She'd taken an overdose of pills. Daughter did not live at the home, but she had a key. She called the police, went to the mother's home, and then she let the police officers in. Apparent authority. She had the apparent authority. Can consent be withdrawn? Yes, consent can be withdrawn. There's a right to revoke consent once it is given. However, consent cannot be revoked retroactively after the officer has found incriminating information. Revocation must be made before the search is completed, and it must be clear and explicit. So, you can withdraw your consent. Officers, you can search my car. Once they start searching, say, the officer, I retract that. I don't want you to search my car. Just please stop searching my car now. They must stop. They have to stop. You can withdraw your consent. But it doesn't apply to something they've already found. They found the drugs, now they're looking for the money, they're looking for something else. The drugs are going to be admissible because they had consent to search and they found it during the term, during the time period that the consent was valid. And thus, anything that's found before you revoke the consent is going to be admissible against you and will not be suppressed. Let's look at a couple of cases very quickly, a couple of very recent cases. One of the cases is Georgia. One of the cases for consent is Randolph versus Georgia. In Randolph versus Georgia, wife and husband got into an argument, and wife decided that she was going to move out. They were arguing over the son. She had moved back in. She decided, okay, I'm going to move out. She called the police for the purposes, again, of helping to effectuate the move. Police came in, and then she was moving her stuff. Husband was there, and husband was there during the time that police came in, was helping her move her stuff. And then she says, husband does drugs. He has his drugs upstairs in the bedroom. Now, they asked for consent. She says, yes, you consent. Husband was there. They asked the husband, could they search? Husband said, no, you cannot search. The court said that, and they searched based upon the fact that the wife had given consent, and that wife had apparent authority, and she had authority to give them consent to search the home, just as the husband had authority to give them consent to search the home. And let's assume she did have the authority to give the consent to search the home, and both had the authority. But the court said that if one person, if you have two co-inhabitants, you have two co-tenants, and both co-tenants are there, and one of the co-tenants object to the search of the home that's requested by the state, then the state or the officers cannot search at home. They said, our opinion in Randolph, very, let me find very quickly what the court said. The court said that when you consider this, when you consider the fact that you have two co-inhabitants, that no reasonable person would believe that he can actually go into a home when the other person has decided that they don't want him there, that the person would not feel comfortable coming into the home, and thus the state does not have a right to come into the home when the person is present, and he denies consent. Thus, if I am in my home, wife give consent, I said no, they cannot search. There was a twist on that. Alito in Fernandez versus California. Fernandez, they came to the apartment. He and his girlfriend were there. Fernandez, they came in, they asked for his consent to search. Fernandez says no. They arrested Fernandez and took him away, and they took him downtown. Now, girlfriend was still there, and girlfriend was living with them, and girlfriend had the right to give a consent to search the apartment. When they took him away, they asked girlfriend, could they search? Girlfriend said yes. Girlfriend said yes, you can search. And they searched the apartment. The court found that that search was valid. They said that Randolph only applies. Randolph, or the rationale for Randolph's, will only apply when the objecting person is present and not absent. And it doesn't appear for which reason he's absent. Our opinion in Randolph took great pains to emphasize that its holding was limited to situations which the objecting occupant is physically present. We therefore refuse to extend Randolph to the very different situation in this case, where consent was provided by an abused woman well after her male partner had been removed from the apartment they shared. Thus, if the person is removed from the apartment, and then the other person gives consent, even though the person said that I don't want to give consent, then that consent is valid. Really interesting. Really interesting. At one point he said you couldn't consent, but he has to be present in the home for Randolph to apply. Again, the rationale behind Randolph was that a person would not feel comfortable if the other person was there and he says you cannot search. To read one last thing, we're gonna end this video. It seems obvious that the calculus of this hypothetical caller would be quite different if the objecting tenant was not standing at the door. When the objecting occupant is standing at the threshold saying stay out, a friend or visitor invited to enter by another occupant can expect at best an uncomfortable scene and at worst violence if he or she tries to brush off the objector. But when the objector is not on the scene, the friend or visitor is more likely to accept the invitation to enter. So the objector has to be on the scene. He has to be on the scene because it will cause a very volatile situation. He will not feel comfortable, or it might end up in something worse, according to the court. Very interesting. Thank you so much. We'll see you in class on Monday.